It sort of starts to feel like spring a little bit outside, sort of. I just want to say what an honor it is to have Callisti and the Georgetown undergraduate chapter join us today, where I started my FedSoc journey, and I'm glad to see the chapter is as vibrant and active as ever. This series, of course, was named in honor of Daniel Webster, one of our nation's greatest orators, public servants, and advocates. Founded just last year, the series has already become the heartbeat of our chapter and a cornerstone of the intellectual conversation here in the nation's capital. By bringing together leading judges, scholars, and practitioners from across the country, we aim to engage the most pressing legal and policy issues of our time. Tonight's resolution was Dobbs correctly decided, addresses what I think we can comfortably say is one of the most, not the most, controversial opinion of the century. Few decisions in history have generated such sustained legal, political, and cultural debate. In overruling Roe and Casey, the court did not merely alter abortion jurisprudence, it fundamentally reshaped the constitutional landscape, reigniting deep questions about stare decisis, the role of history and tradition, federalism, and the proper bounds of judicial authority. So to explore this ever-relevant and rich issue, it is my great honor to host this evening's program featuring two of the nation's leading experts on the issue, and to welcome for the third time, Judge Ana Reyes as tonight's moderator. I'm glad to finally be welcoming her for a conversation on a controversial topic after she previously moderated debates on light topics of Citizens United and the powers of the federal government. So without further ado, please join me in welcoming our Director of Debates, Louis Pham, who will formally introduce our three distinguished panelists. Thank you so much, everyone.
Good evening, everyone, and thank you for coming to tonight's debate. Our moderator is Judge Ana Reyes, who served as a law clerk to Judge Kirk on the U.S. Court of Appeals for the Second Circuit. After clerking, Judge Reyes became a litigation attorney at Williams & Connolly, where she spent her legal career as a co-chair of the International Disputes Practice Group and on its executive committee. She also devoted substantial pro bono time to assisting refugees in organizations that assist refugees in obtaining asylum. She obtained her JD, magna cum laude, from Harvard Law School, and her undergrad degree at Transylvania University. Professor Elizabeth Kirk is Assistant Professor of Law and Co-Director of the Center for Law of the Human Person at the Columbus School of Law at Catholic University of America. Her scholarship focuses on law and the family, including issues such as parental rights, reproductive technologies, abortion jurisprudence, child welfare, and adoption. Her work has been published by the Institute for Family Studies, First Things, and the Texas Review of Law and Politics. Kirk holds an undergraduate degree in English Literature from the University of Missouri, a law degree from the University of Notre Dame, and has done graduate studies in theology. She studied jurisprudence with Charles E. Rice and John Finnis. And then I'll introduce Dr. Franks before she arrives. Dr. Franks is the Eugene L. Barbara Bernard Professor in Intellectual Property, Technology, and Civil Rights Law at the George Washington University Law School. She's an internationally recognized expert on the intersection of civil rights, free speech, and technology, and her areas of expertise also include family law, criminal law, civil procedure, First Amendment law, and Second Amendment law. She previously taught at the University of Chicago Law School as a Bigelow Fellow and lecturer in law at Harvard Law, and she holds a JD from Harvard Law School, as well as a doctorate from Oxford University, where she studied as a Rhodes Scholar. And as always, the Federalist Society takes no position on tonight's debate. Thank you for coming.
Did you say that she had come?
She's about to be here in like a few minutes.
A few minutes?
Yeah.
All right, I guess I'll get started. When I agreed to do this event, I think it was like a couple of months ago, and I was asked to moderate a debate about whether Dobbs was correctly decided, I was concerned that I might inadvertently say something that would be controversial and blow up social media. Did not have to worry about that for today. That has already occurred, apparently, as we discussed earlier. So now that the day is upon us, I just want to thank the Federal Society for asking me to moderate this debate on Roe, Dobbs, and abortion, or as I like to think of it, the least controversial thing I'm likely to do all year. I thought a lot about what I would say in this introduction, and to be honest, I thought, you know what, why not just take a position? Why not just lay it all out, give my unvarnished views as to what I think about the Dobbs decision. Who needs law professors who specialize in this when you have a district court judge who can just say whatever she wants and push the limits of good behavior? So I had it all ready to go, and then I decided, before I give you my unvarnished views, I should check Twitter to make sure I hadn't missed anything about what people were saying these days about Dobbs. So I went to Twitter to sort of read up on Dobbs, and instead I found out that some people have some very, very strong opinions about me. And if you allow me a quick digression, I will give you some of the quotes that I have read online, and if you just allow me a bit of time to respond, because there's some information out there, and there's some curse words in here, and they are not mine, I'm just quoting. So some tweets included that I am a, quote, fucking lunatic, and, quote, hysteric lesbian who writes like a, quote, freshman political science major, and, quote, needs to go back to law school. And look, whether I'm a lunatic or hysterical is totally in the eye of the beholder. I'm sure, like, reasonable people can disagree on that. I'm sure I have an ex or two who would more than agree on that. Speaking of exes, as many people have pointed out, yes, I am gay. I'm also single, so if all the people who think that me being gay apparently is relevant to my decision making, if you could just add that to your tweets, that would be helpful to me, because maybe I can get a date out of all of this. I think in all fairness, my opinions write at least like a junior poli-sci major, maybe even on a good day a senior one. And for the record, I got all A's in my poli-sci classes, so. And finally, here I am, back at law school. So I am back at law school. People have told me I should be back, so here I am. Now I have some bad news for you guys. A Cracker Jack sleuth found me out. Someone posted, quote, "You look here, Ana Reyes is an unlawful judge. It is law 8 U.S. Code 1324A, unlawful employment of immigrants, not allowed to be in any government job. It is the law." So I'm sorry to say that apparently the White House, DOJ, Senate Judiciary Committee, FBI, and ABA all missed that I am legally not qualified to serve as a judge. The bad news for you all is that now I don't feel qualified to give you my unvarnished view on Dobbs. So I'm going to keep it to myself and remain neutral so that I don't anger the Twitter bots any further.
Nothing awkward about this at all. That's totally good. Exactly how I planned it. Dramatic entrance.
Yeah, they said some really mean things about you. Okay, you have more credentials.
So.
I just noted that you had a great presence. All right, so this past week has, however, impacted other things about what I think and about today's debate. And here's, I think, what the past week might have taught me, and I will leave this up for discussion, which is arguably we are not having a debate at all about whether Dobbs was correctly decided. I think one could argue that most people who are pro-choice think it was not correctly decided, and most people who are pro-life think it was correctly decided. And some could argue that all we do when we debate Dobbs is debate abortion through the lens of legal theory and case law. But where we end up depends almost entirely on where we start. Don't we all, on both sides of the debate, just reverse engineer our legal views to support our political views? Consider the following thought experiment. Dobbs was decided first in 1973. It's 2022. The Supreme Court has 6 members appointed by Democratic presidents, and it is poised to overturn Dobbs. Roe comes up before the court. Now, how many of those who today think that the court was wrong to ignore stare decisis would still think that? And how many of those today who think the court was obligated to overturn an egregiously wrong decision would be so quick to discount stare decisis? Which leads to the following. Does this debate really matter? Is there really anyone out there who is going to change his or her mind on Dobbs based on anything anyone says? So that's one take. A different take is, I think all of us can agree, I hope, that reasonable and rational judges acting in good faith can call strikes down the middle and yet reach diametrically opposed conclusions. Not because they have preconceived personal views from which they work backwards, but because, as I have said before and welcome thoughts on, different legal theories, different approaches to the law are, for purposes of our analogy, different strike zones. Judge A can have a tight strike zone and call something a ball that a judge with a wider strike zone calls a strike. Both are rigorously and in good faith applying the facts as they understand them to the law, which is, for these purposes, the strike zone as they interpret it. And so when we debate Dobbs, it's important to understand the majorities and minority strike zones. And an equally important question, do we see that these same justices apply these same strike zones across cases with different subject matters? And so one of the things I hope that we get out of debate is, why are we here? Why are the professors here talking about it, and why are all of you here listening to it? And with that, I am going to stop talking and turn it over to one of the professors.
All right, before I begin, I just want to express gratitude to the student organizers, in particular Louis and Dennis, for organizing tonight's event, for shepherding us so well. I'm very impressed with the turnout, so I'm really grateful to be here with all of you. Judge Reyes, Dr. Franks, it's good to be with you. We haven't met yet, but nice to see you. Okay, so we know that in 22, in Dobbs, the Supreme Court overturned Roe versus Wade, holding that the Constitution confers no right to abortion. In response to the resolution, tonight's resolution, was Dobbs correctly decided? I argue in the affirmative. I expect many of you have read the decision and know how the Dobbs court explained its conclusion regarding the right to abortion and its stare decisis analysis. And in the interest of time, I'm going to focus my remarks on the correctness of the court's conclusion that the Constitution does not protect the right to abortion. The Constitution makes no express reference to abortion, and therefore we are faced with the question of whether the Constitution necessarily protects activity or conduct upon which the text itself is silent. Now, the question of unenumerated rights has long faced the court, and tonight is probably not the night we're going to resolve the doctrine of substantive due process or ask whether the slaughterhouse cases were rightly decided. Under the governing Glucksberg analysis, we must ask, in order to ask whether Dobbs was correctly decided, whether the asserted right is deeply rooted in the nation's history and tradition and implicit in the concept of ordered liberty. Abortion meets neither criterion. Far from being thought of as a constitutional right, the unbroken legal history of this country from its founding until the day Roe was decided was to criminalize abortion at both common law and under statutory law. Indeed, at the time of Roe, 30 states still prohibited abortion at all stages except to save the mother's life. You might hear counterpoints, right? The fact that the law allowed exceptions, or that pre-quickening abortions, that is, those that occur before the mother could feel the baby move, that those weren't always felonies, or that certain religious views delay personhood until birth when the child takes its first breath. Those are beside the point for tonight's resolution. They are policy debates. They are references to outdated embryological understanding of embryology. They are theological disputations. They're all very interesting, but they're not constitutional analysis. The historical point in Dobbs isn't unanimity on these points or on enforcement of law or of fetal status. The historical point in Dobbs is that no one reasonably saw abortion as a constitutionally protected right when it was widely criminalized. Now, in order to avoid the obvious conclusions of this history, Roe instead situated its right to abortion in the right to privacy, itself originally extrapolated in Griswold from, and you all, at least the law students, are familiar with the emanations of the penumbras, of various constitutional amendments to protect marital privacy, but quickly expanded to encompass much more, and made possible, I think, by the Easter egg planted in Eisenstadt, the notion that privacy included the right of an individual to decide whether to bear or beget a child. Of course, it's not until Casey that the right to abortion is squarely described as a liberty interest, and even then it's downgraded from a fundamental right, which previously had required strict scrutiny. So Dobbs rejects convincingly, I think, the argument that a right to abortion, though not present in the historical record, is somehow an integral component of this broader privacy or liberty right. The court points out that construing liberty in an absolute sense could license such uses of our bodily autonomy as drug use or prostitution, conduct about, again, which we may have interesting policy debates, but which few people think are constitutional rights. While many subscribe to a capacious notion of liberty as the freedom to define one's own concept of the mystery of human life, very few people actually live that way, at least not entirely. There are orders or rules that we all acknowledge we are subject to that we do not define or choose for ourselves. Some of those are positive laws, like traffic laws or zoning laws. Some are physical laws like gravity. Still other are moral laws that may be incorporated into human positive laws, such as those against killing or stealing or the recklessness standard in tort law. Operating within those laws does not inhibit our liberty, but rather recognizes our social human nature and allows us to live well together. So ordered liberty, my point here is that it can't mean whatever we want to do, unfettered freedom. Rather, ordered liberty, as the Dobbs court puts it, is a principle that sets limits and defines boundaries between competing interests. So we might think of the right to marry or parental rights as being unenumerated rights that are part of ordered liberty, right? They're not mentioned in the Constitution, but few dispute that protecting them, setting limits or boundaries on the state's ability to interfere with them, is integral to a well-functioning polis. But construing liberty to set a boundary against abortion regulation is not necessary in the same way. Why? What distinguishes abortion from other protected and unenumerated rights, and I suspect we'll get into this a bit in the Q&A, but in overruling Roe and distinguishing the liberty cases from those involving the right to marry or privacy within marriage, the Dobbs court, like Roe and Casey before it, observed that abortion just is something different in that it uniquely involves destroying potential life or an unborn human being. So think of it this way. Even though a right to contraception is not historically rooted, right? One could argue it too used to be criminalized. The idea that there is a realm of privacy or sovereignty in marriage is deeply rooted in history. And those who've read Griswold will recall how horrified Justice Douglas was at the thought of searching marital bedrooms for evidence of contraception, right? But even marital privacy cannot be a shield to harm, such as domestic violence. The question of privacy is just less relevant in this case because a matter of justice prevails. Similarly, we cannot say that abortion, an act which uniquely involves the destruction of human life, is necessarily part of a broader liberty right. Now, of course, some may not be convinced by any of this because they see no reason that constitutional rights should be constrained by the past. The Constitution should evolve to reflect today's values according to this way of thinking. But I would submit that Roe was no model of democracy. In one stroke, it struck down the abortion laws of all 50 states, going farther than any state at that time had gone in allowing abortion, and generated 50 years of contentious national debate. So even if rights should track popular views, notwithstanding that rights exist precisely to protect against shifting majorities, judges have no special insight, no offense.
Plenty of people think I have no special insight.
Judges have no special insight, I didn't say you didn't have insight, no special insight into what those views are. Elected representatives accountable to the people reflect them far better, which is what Dobbs now permits. Thank you.
Thank you.
Justice Alito's opinion in Dobbs is almost 80 pages long. In it, he discusses many, many things. He talks about how the question of abortion is a profound moral question. He talks about how unique it is. He talks about the destruction of potential life and says that that's what makes this question different from all other questions. He dismisses pretty much out of hand the idea that restrictions on abortion in any way implicate equal protection. And he gives us a tour through history and tradition to justify the decision that he makes and the majority makes. Now, his tour through history and tradition is a little selective. There are some parts that he likes more than others. And he tells us why there is no constitutional textual right to abortion. He talks about how we need to leave this to the states, return the issue to the states. He talks about how there's no real reliance in the stare decisis. He talks about how bad the reasoning was in Roe and Casey. He talks about how Roe is wrong when it was decided and implicitly compares it to Plessy versus Ferguson. He gives us a very intellectual, legalistic run-through of why he is coming to the conclusion that he's coming. But I would say he could have saved himself a lot of pages. The takeaway of Dobbs could be summarized in a 5-word phrase that was posted on the social media site X by the admitted neo-Nazi, self-described incel Nick Fuentes at 11:10 p.m. on November 5th, 2024, the moment where it became clear to most people that Donald Trump was going to be president again. The tweet was, "Your body, my choice, forever." Fuentes' post racked up 90 million views and was reposted more than 35,000 times in the week that followed. Mentions of the phrase increased by 4,600% within a single 24-hour period. Women's social media accounts were flooded by the phrase and with graphic threats of rape and forced pregnancy. School-age girls reported that they were being taunted with the phrase at school. This was also accompanied by posts calling for the repeal of the 19th Amendment. The phrase, of course, was an invocation and a riff and a kind of parody of the expression, "my body, my choice," which has long been associated not only with reproductive rights, but also with women's expressions of autonomy more broadly, both in the United States and around the globe. The idea of my body, my choice is a rejection of history and tradition. It's a rejection of a long-standing history and tradition of treating women's bodies for forced labor, whether that labor is childbearing, whether that labor is sexual, whether that labor is being the whipping post for an abusive husband. My body, my choice was intended to express that women and girls have the right to control who has access to their bodies. Fuentes' parody of that phrase was a smirking, predatory refutation of that right. It was a kind of victory. It was an expression of hostility, but also of warning. And indeed, there was really good reason for someone like Nick Fuentes to celebrate. Supreme Court, that includes 2 justices who have been credibly accused of sexual abuse, delivered a decision that was stripping women and girls of the right not to be forced to give birth against their will, followed by the second election of a confirmed serial sexual predator to the highest office in the land. It's a good time to be a predator. There is no way to distinguish or to disentangle the idea of forced sex and forced childbirth, or for that matter, forced sterilization. If we think about what we really mean when we say that the state is allowed, as the dissent points out in Dobbs, the state is now allowed, after Dobbs, to consign a woman to death, if it so chooses, to regulate abortion in that way. And that really means that the woman has no choice, and if she has no choice over her body in the sense of life and death, what other choices might she have? So it was a vengeful reckoning. It was we are returning to history and tradition, the history and tradition of controlling women's bodies through men's choices. And that's why it is really fitting that Alito cited Matthew Hale and William Blackstone to point to them and say, look at our history and tradition of these particular figures who have told us that abortion was always a crime, that abortion was a great offense. This is the evidence that is given for saying we have this history and tradition. What is really interesting when we look a little closer, especially let's say at Matthew Hale, let's think about what in his 1736 writings he did not think was a crime. He did not think marital rape was a crime. These are his words. The husband cannot be guilty of a rape committed by himself upon his lawful wife, for by their mutual matrimonial consent and contract, the wife hath given up herself in this kind unto her husband, which she cannot retract. That is the authority to whom we are citing when we talk about taking away the right for a woman to not be forced to give birth against her will. Or let's look at Blackstone, who was cited by the majority in Dobbs 21 times. Here's something that he didn't think was a crime, even though he says that abortion was. Husbands can give wives moderate correction as long as it is reasonably necessary. Let's put this a little less politely. A little light domestic violence is not just not a crime, it's a husband's prerogative. When the dissent says that what is happening in Dobbs is power and not reason, that the currency of this current court is power and not reason, this, I think, is what they mean. That what the hostility has been building up for all of these decades since the Roe decision has been hostility that is just waiting for the right political moment to come to force and to send women back to a very specific history and tradition. And while it's at that, it's also going to consign women to death, to injury, and to violence. The impact of Dobbs so far, abortions nationwide have increased. That's one point. Almost 20% in the 2 full years post-Dobbs. Literature reviews that have shown that in Texas, as an example, in terms of the deadliness of pregnancy and childbirth, maternal mortality has risen 56% overall, and 95% again among white women during the first year of its post-6-week ban. 50% increase in maternal sepsis during this time, whereas mortality decreased by 21% in states that were permissive when it came to abortion rights after Dobbs. It's not just the question of mortality rates for the pregnant women. It's also going to have a racial impact. We should note that Black mothers living in states with bans are 3 times more likely to die during pregnancy, childbirth, or postpartum. But a study that was published by Johns Hopkins in 2025 found that there is an increase of 5.6% in infant deaths. So more children are dying post-Dobbs. This is even more striking for Black infants, whose mortality rate is rising by 11%, 21% for non-Hispanic Black babies. We've also I think, probably heard the stories of women being forced to carry dead fetuses, forced to travel, to wait, forced to find different states that will give them the procedures that they might need to save their lives, or in the case, for instance, of a 10-year-old rape victim, probably to save her life, but also to save her from many other forms of injury. We know about the confusion and the chaos this has caused for women who actually want to give birth, but something goes horribly wrong, and they show up in the emergency room and they think that they're going to get the care that they need. We're hearing over and over again that medical professionals are saying because of the post-Dobbs landscape, they're not sure how much aid they can render because now all of this has been called into question. The chilling effect has affected even the cases where women would have typically been provided emergency care without questions. And what we've seen in the other cases that touch on abortion, medication abortions, the EMTALA cases, we see it over and over again, the image of what Alito and people like him see when they talk about abortion. What are the words that he uses? He talks about the unborn child, the potential human life, about the harm, about EMTALA, emergency care for women, for the patients who are experiencing crisis. What does he talk about? He talks about fetus, as if it were sort of floating in the ether, disconnected to anything else. And then when the Solicitor General sort of calls him out on this to say, what we really are focusing on with the EMTALA law is whether or not we can support the patient. And he screams at her. No one is suggesting that a woman is not an individual and she does not deserve stabilization. Nobody is suggesting that. But of course, that was precisely what Alito was suggesting and what he was, in fact, doing. So we can talk about the weaknesses of Roe and Casey. I think I would agree with a lot of the critiques about Roe and Casey, but maybe from a different direction. Roe was weak and Casey is weak because they did not, in fact, phrase the question correctly. The question is not whether there is no right to an abortion. The question is whether or not the state has ever got the right to tell a woman or a girl that she must give birth against her will. Do women have the right to not be forced into pregnancy and childbirth, or do they not? That is the only question that should have ever been asked. And so when you get the kind of wavering in Roe and about how this is something we cannot isolate a woman in her own privacy, this is different from anything else, think about the case that Blackmun uses to defend restrictions on abortion. What's the case? Buck v. Bell, the forced sterilization case. He says, that's how we know that it's okay for the state sometimes to just make up its own mind for you, for women's bodies, what is best. So, where does that leave us when it comes to Dobbs? So there's a lot more that we could say, but I would say here's where we really do end up. It is probably true to say that the Dobbs decision is a return to history and tradition. It is a history and a tradition that subjects women's bodies to men's choices, and it's not going to be a decision that will be contained to the pregnancy question or to childbirth at all or to women at all. And it is the kind of world in which fetuses, perhaps embryos, it seems maybe, are treated as maybe full human beings, but it is also a world in which women and girls are not. Thank you.
All right, thank you. So I have some questions. I'm going to take this opportunity to say I am totally neutral on this. Whatever my questions might suggest or not suggest, please no one take it out of context. I am just here to ask questions. So my first question is to both of you, and I sent it last night because I was thinking, why am I doing this? And I'm thinking, why are you guys doing this? So why are you here? I mean, the chances that there's anyone out here with an open mind who is willing to be convinced as to whether, or who doesn't have a view as to whether or not Dobbs is correctly decided, I'm going to guess is somewhere south of zero. So why are you here?
I don't love debates, actually, so it's a good question, I think. I prefer discussions, but I think one of the reasons I'm here is I want to encourage the fact that you're interested in this, in this topic. I think it's really wonderful, especially in today's fraught and kind of unpleasant and uncivil discourse, to have young people who still have hope that we can have hard conversations. And then go out to dinner afterwards and, get to know each other. I think that's really wonderful, and so I'm glad to be here for that.
Okay.
I don't know if I agree necessarily that people wouldn't change their minds or that there's no chance. I'd like to think, I think about myself as a law school student, as a college student, and I had really, really firm beliefs about many things. And it wasn't as though there was ever maybe a talk that was so incredible that suddenly changed my mind, but there were certainly many moments throughout my education where there was a sort of a seed that was planted, something that made me think, well, maybe I'll return to this thought because something about that is kind of bothering me a little bit, or I don't quite know how to resolve that. So I like to think that part of the pedagogical project, something that I like to bring into my classes, but also in events like this, is whether we can do that for each other. And I do mean that as kind of a mutual question because I think that can happen for anyone, no matter how strong their beliefs. And that even if we're not ultimately going to change our minds, this is a classic kind of libertarian position of saying, well, it's good for us to talk about our reasons because we want to make sure that our reasons are good. And we want to think through some of the implications of our principles and our values because we may not have thought about the consequences of those. And so I always appreciate the chance to do those things.
All right, well, thank you to both of you for doing it and being here. Let me start with you. So in terms of seeing the other side, what is the people who think Dobbs was correctly decided, what is their best argument? What is the argument that sort of keeps you up at night and you think to yourself, yeah, that they have a point?
So I don't think it keeps me up at night, but I would say, and I hinted at this a little bit in my opening statement, I think that Roe and Casey are very badly decided cases. When not even just in the version where Alito says, look at how bad this is, but even at the time of Roe itself, when people were saying, this is made up on top of made up, right? And then you get to Casey and it's like, well, we're going to take some of the made up stuff and get rid of it and put in more made up stuff. I think that that's fair and that's true, and that Casey in particular, even as the decision was purportedly clarifying things and validating the central part of Roe, that it really was just causing a lot of confusion, and that it was not settling the issue and it didn't make it less controversial. So I think that that is true.
Yeah, I would agree that I'm not being kept up at night about the reasoning in Dobbs. I would say that to the extent, this doesn't go to the argument in Dobbs, but I think to the extent that the drivers for abortion, many of which you recounted in your remarks, maternal mortality, poverty, violence, those kinds of things, to the extent those are drivers for abortion, we should be addressing those, right? And more intently and more directly. So I think that's something that.
Well, yeah, I mean, okay, but that's just like a policy argument. Like, what's wrong with the reasoning of the decision? Anything?
Of Dobbs?
Yeah.
I mean, I'm very convinced by the historical argument. I mean, I think it's very straightforward. I think for the reasons that Dr. Frank said, Roe and Casey were weak, Dobbs is strong. I think if there were any area of Dobbs, again, this doesn't go to its holding with respect to abortion, that I can see the argument that, or the concern that some have about the limiting principle it used to distinguish abortion from the other unenumerated rights, right? So the other liberty interests, I think that's, to me, less convincing than the strong historical record.
So let's stick on the historical record for a moment. You would agree with me that in the 1700s, 1800s, especially in the 1700s, largely in the 1800s, women did not have an equal role in society in terms of being able to engage in debates about how we're going to structure the Constitution.
Yes.
Okay, and so, whether or not we assess what was being put into the Constitution at the time, does it really make sense to argue about or to think about whether abortion was criminalized at the time when the people who are affected by the laws had no role in instituting those laws?
I mean, I think that, you know, we have to throw out an awful lot, right? If we're gonna criticize the whole Constitution on the grounds that women and other groups of people weren't participating politically.
Well, no, I'm not criticizing the whole Constitution.
Right,
I'm saying if we're gonna look to
And the
what they
laws
were.
at the time, right?
Right, I mean, well, why are we looking to a time period when women did not have a role in making the laws, to figure out what the laws were, to then address what women's rights are today?
Well, I mean, I think that's what the historical analysis is to look at the laws of that time. But I think if the implication is that if women did have a political voice, they would have enacted robust abortion protections. I find that a little paternalistic. I mean, I think I'm a woman. I know many women on both sides of this debate. I know many women who advocated, you know, before the, you know, in the Dobbs case itself. After Dobbs, I know many women in states around the country who are advocating for pro-life positions. So I think it's presumptuous to say that women, had they had the vote, would have wanted abortion.
Okay. Human life. She has a point that we have a privacy interest that the Constitution can protect up until the day that there's privacy interests run into potentially destroying human life. And doesn't that make abortion separate in the way that we think about it with respect to the Constitution and privacy interest? And yes, of course, women should have autonomy over their bodies, but women also have bodies that create and sustain life, and we have to take that into account. It's just not as easy as women can do whatever they want, whenever they want with their bodies.
I guess I think that it is that easy. I think that one of the things that is confusing about the abortion debate is that I think there is a kind of faint-hearted pro-choice position that says, well, you know, there should be abortion rights except when it makes us uncomfortable. And I'd say, you know, it should all make you uncomfortable, and we should just concede as much, right? We either have a right to bodily autonomy and that looks intimate sense, or we don't. Does that mean that any of us have full control over only our bodies and we can do whatever we want and whatever injures someone else? No. But what I find so interesting about the particular timing of just, if we just take the timing of the Dobbs decision, right, it comes after Bruin. And what I find so fascinating about the fact that you look at those two decisions, you've got the court saying, well, we have this, you know, Second Amendment right that's been around forever. It's always meant individual right to bear arms in self-defense, which is nonsense, right? If you want to talk about historical analysis that is easy to disprove, it is absolutely clear that that was never what anyone thought that right meant until you got to the very extraordinary decision, right, that even someone like Judge Wilkinson would say there's no basis for this, right? And the reason why I point this out is not just because I think you can say literally everything that you want to say about the abortion right, if that's how we're going to conceive of it. You could say exactly the same thing about the individual right to bear arms in self-defense. And I mean that right up to and including that whole potential life stuff, right? If abortion is a threat and needs to be treated differently because it's the destruction of potential life, use of weapons in self-defense actually is about terminating real life that everyone agrees is in fact a life. That's at least as serious. So if we're serious about that, then we need to ask ourselves why it is that we think that these two things can be treated so differently. And just for fun, the most fun I've ever had writing an amicus brief, and that bar is low, is when the Rahimi case came up, the domestic violence question, whether or not you can sustain this regulation in the face of Bruin's really, really broad holding. I wrote an entire amicus brief where I said, if Dobbs is correctly decided, then the next step that you would have to take here in Rahimi, and you should take it now, is to overturn Bruin and to overturn Heller because they track each other pretty much identically.
Any thoughts on that?
I think that the self-defense argument, I mean, we're not debating whether Bruin is correctly decided, right? That's not tonight's topic. But I think that the self-defense argument, it doesn't pertain, I think, in the abortion context. The child in the womb is not an aggressor. The child is passive and innocent. And the proportionality element to self-defense simply isn't there in the context of abortion, right? You've got something like 96% of abortions are elective. Very, very few abortions are indicated because of the life of the mother, that her life is being threatened. And even in those cases, I think medical treatment aimed at saving both lives or the mother's life, if you can, right, is what most doctors aim to do. In contrast, an abortion, right, is the intentional killing of the unborn child. And so I think, when we talk about a failed abortion is one where the child is born alive, right? If you have a woman who is her life is in danger, I just don't think the analogy to self-defense is there, because you can act to save her life.
So if I can respond to that, because I spend a lot of time when I'm not talking about abortion, talking about self-defense and criminal law. When you look at the doctrine, this is what's so interesting, is that it turns out that the idea that you can't use deadly force against someone who's not aggressive, or who isn't, that you're not 100% sure that they're going to kill you, turns out that is not the dividing line. Self-defense, the entire doctrine of self-defense says, if someone poses a threat of grievous bodily injury, right, to a reasonable person, or if they pose a threat of kidnapping or sexual assault, you're allowed to use deadly force, and that deadly force could kill that person. And it doesn't actually matter if that person isn't trying to be aggressive towards you. There are actually all these hypotheticals we talk about in criminal law that says it's the baby with the gun hypo, right? The toddler picks up a gun and points it at you, has no idea what they're doing. They're just waving the gun around. Do you have a right to shoot the child to make sure that you don't get shot? And the answer is you do. Now, whether or not you should, or whether or not you would want to find another way the law would say that you are allowed to do that. And you do not need to wait until it's 100% sure that it's going to happen. There are calculations we would make about the reasonableness of your assessment about how much the proportionality of the force was. But if anything, the doctrine of self-defense has become more expansive over time, not less. So the idea that it would have to be, well, you have to know the precise moment at which this pregnancy is going to kill her, and then maybe we'll let her, as a treat, be able to defend herself so she doesn't die. Well, who's to say that, right? Why would we have that kind of particular mandate for women, pregnant women particularly, not just women, pregnant girls, right? Because 10-year-olds and 11-year-olds can be pregnant. So why would we suddenly say, well, the standard for them is totally different, right? Just because it just so happens that the threat is coming from inside, right? Why would it make any difference? We actually do have a pretty robust standard that says we're allowed to use deadly force even when someone does not mean to be aggressive to us. And even if it is not something that is going to kill us, certainly not 100% sure that it's going to kill us.
I can just say one thing, sorry. So I guess I would just say that I don't view the child as an aggressor, and I think that the laws, even the most abortion restrictive laws, allow exceptions for the life of the mother.
But why should they?
Excuse me?
Why should they? Here's the other thing that's funny about criminal law. If someone is not an aggressor towards you, as you're saying, in the law, you're not actually allowed to kill them to preserve your own life, right? If that's what you're really going to present, is that these are two equal people. It's the Titanic, right? There's room for both of you. Well, if we argue that maybe there's not, that there's actually only room for one of you, you're actually not allowed to shove the other person off. That is not something you'd find defensible. So why should it be any different? If you believe that abortion is killing, you actually think it's the same thing as murder.
So my point is not that I believe that you should kill an unborn child to save the life of the mother. That's not my point. My point is that I find these hard cases arguments really frustrating, because very few people who make them think that abortion should be illegal in all cases except to save the mother's life, right? We're not arguing about that. We're arguing about whether women should be able to have an abortion, as they do in 96% of the cases, for any reason whatsoever, right? Including whether the child is a girl, right? Or what insert the reason that you find, unacceptable. And so my point is simply that those hard cases, right, are very few, and if you're worried about the woman whose life is in danger, she will be able to obtain an abortion in that case. That's my point.
Okay, well, let's get back to Dobbs. Dobbs did not say that women have the constitution, that women are constitutionally barred from having abortions. Dobbs said, basically, it's an issue that should not have been left to the courts. It's not in the Constitution. If you want it to be in the Constitution, by all means, have a constitutional convention. If you don't have enough votes to have a constitutional convention, this is why we have a federalist society. This is why we have a federal system where we have different states. And as you know, we've just stated earlier, not all women are going to be for abortion. Not all women are going to be against abortion. Men, who knows, whatever. I'm from Kentucky. Kentucky had a law that was up, I think it was for a referendum, and everyone thought Kentucky's clearly going to pass this anti-abortion referendum, and they did not. Isn't it intellectually more honest to say, as a legal matter, Dobbs did the right thing in taking this out of the land of the judges, the unelected judges, and putting it back into the land of the states?
No.
Okay, well, I need more than that, because otherwise we're not going to be here very long.
So we can say this about, I think all of this could be true, except that the entire point of contested constitutional rights is that there's things we take away from the democratic process because, let's face it, the democratic process is not great. Leave things up to the democratic process, you know what you get. You get some states that still have slavery, because why wouldn't you, right? You still get some states that would say that you can't have interracial marriage. You still get states that would say, as I'm sure many people want to be true, that same-sex marriage is not okay. You could, right? But there's no reason to think that this, unless we're already assuming the conclusion, which is that somehow there's something less significant about this right. I would say the ability for someone to control access to their own bodies, it doesn't get more substantial than that. And the fact that people want to subject that to a democratic vote, should women be treated as full human beings? No, that is not something that we should vote on. That is the kind of thing that history has taught us. We don't let other people decide who gets to be a full human being.
Why should this be left to the states? Why was Dobbs correct in saying that?
So I think it's, the court said the issue should be returned to the people. So I just want to clarify that, because often they say the states, and there is some, to the extent there's authority for it, right? There could be some role for the federal government as well. And I think people on both sides of the issue have tried to, use federal authority for their ends. So I agree, actually, with Dr. Franks that the democratic process is messy and not always satisfying, right? I mean, I was very involved in the Kansas amendment, which was a neutrality amendment, and it was an incredibly difficult process.
What's a neutrality amendment?
So the Kansas Supreme Court had found a right to abortion in its state constitution before Dobbs. And so the legislature passed an amendment that went on the ballot for the people to consider that would have rendered the Constitution neutral on abortion, leaving the issue up to the people through the legislature. So it didn't the amendment itself didn't take a position on abortion, but it would have neutralized that previous state Supreme Court decision. And it was just very difficult. I mean, it's very difficult to have conversations with sort of ordinary voters, right, about the strict scrutiny standard of review and what a right, and many people don't know that the state had a constitution, right? And so to explain to them the issue at stake and to describe, the various political positions, and then against the backdrop of really, I think, disingenuous arguments by the other side, things like, well, if this amendment passes, again, a neutrality amendment, if this passes, women with ectopic pregnancies will die, or women who seek miscarriage treatment will go to jail. Kansas had a law in the books that allowed abortion for any reason up until 24 weeks and specifically exempted ectopic pregnancy and miscarriage treatment. So anyway, those were, most people, I think, when faced with the idea that women who have miscarriages are going to go to jail and a kind of theoretical unlimited right to abortion, they're going to choose the theoretical unlimited right? Because they don't want people they know to not seek miscarriage care. So that kind of experience was incredibly frustrating. Nevertheless, I think post-Dobbs, these are exactly the kind of conversations we've been prevented from having for 50 years, right? And so these are the kinds of conversations that we need to be having. We need to be talking about how to help women who are pregnant, who don't feel like they can carry the child to term. We know that the majority of women who seek abortions want to choose life, right?
Don't
And
agree with
if
that.
they have, well, we can.
Well, let's not get into that.
But the point is that, well, I think the point I'm trying to make is that most women who seek abortion would choose life if they had the support that they needed. Easy access to abortion is, I think, an easy out for men who don't want to step up to the plate. You mentioned the abhorrent tweet after Dobbs. I saw just as many from men who were worried post-Dobbs that now they have to take responsibility for the children that they father. I think abortion is an easy out for societies who don't want to create safety nets to help women and their children. We know prosecutors who say access to abortion is, a shield for traffickers and predators. So I think these are exactly the kinds of conversations we need to be having. Was Dobbs rightly decided? Yes, it was a pretty straightforward constitutional decision. Now we have the hard work of having these conversations.
So I was struck by something that you said in your introduction, in which you discussed that in the privacy of one's own home and one's own marriage, you can discuss whether or not to have contraception, because contraception isn't taking away life, it's maybe preventing life from coming into existence, and that makes it a different type of privacy right than abortion, in which I think, as you put it, impacts a life. Did I get that right? I don't want to put words in your mouth.
Well, I was summarizing the court's distinction between the two types of rights.
Does that argument assume or necessitate the assumption or is based on the conclusion that that the embryo, that the fetus is a human being life?
Yeah, so
The reason I'm asking is because if it's not a human being, then what distinguishes, say, an early abortion from contraception?
yeah, I think it's an interesting question because the court uses sort of interchangeably the language potential life and an unborn human being. I think this distinction, right, if you buy this distinction, that abortion is something uniquely different from these other privacy interests, does hinge on the humanity of the unborn child, right? That it is the intentional taking of an innocent life. I think the criminal history that the court recounts at length makes no sense, right? They're homicide laws if you don't consider the humanity of the unborn child. So the court doesn't. The court is relying upon, I think, the language that the parties used, the language that Roe used. It prescinds from whether the child is a human being. Obviously, it doesn't even address whether the child is a legal person. But the way I read the case, it only makes sense if the child in fact is.
Could it be a constitutional right for women to have abortions if, in fact, let's just say all scientists agree that a fetus at whatever stage from day 0.1 is a human life?
Scientists can't agree to that because
But
it's not
this is a
scientific
hypothetical. I'm just trying to figure out where you are in
Yes.
your argument. But I'm a little.
So I'll answer it both. One is to say the reason why science can't tell us that because where life begins and what is a human being is in fact not a scientific question. So that is, I think, it's a category error to try to say you can get scientific consensus on what life is, right? Obviously, there's disputes among Catholics, right, about whether it is conception or whether it's remote. No one actually knows. That is not a scientific question. But the thing that I find most interesting about how irrelevant that is that let's go ahead and concede for the purposes of argument solely, because I think that the belief that an unborn fetus is a human being is a religious belief, and that's fine, people can have it, just don't impose it on anyone else. But it's not something that you can state as fact, so we should not be resting anything on that assertion. But even if you were to concede that let's take it as a person, none of what I've said changes. Because it's not a question of whether or not the fetus is a person, it's whether or not the pregnant person is a person, right? Again, we go back to the
Why
idea.
can't it be that both are people, and what do we do when we have two people
Yes.
who are equally
That's
innocent?
this is exactly what I'm trying to say. You have a scenario like that. If someone comes into your house and you don't want them there, you are actually allowed to tell them to leave. And if they don't leave, you're allowed to use deadly force to get them to go out. That is something that means that even if the other person has interest in wanting to be there, doesn't mean that that makes it okay for them to be there. There is still a difference because there is one territory here, and that is the woman's body. We're not talking about true neutral ground, but it's okay if everybody here is a human being. It doesn't matter for these purposes. You're still allowed to protect your own body against someone else's body. And just to be clear, to go back to the idea that yes, we could have conversations about whether or not women are full human beings. Let's go back and have that same conversation about Black people. Let's have the same conversation about interracial marriage and whether or not we should really have done that with Loving v. Virginia. Because we could make every question that is of any kind of import, and we could say, really, people should be chatting more about this. But there should have been, one would say, I would think a more noble and plausible and defensible version of the Constitution is to say some things are too fundamental and too sacred to submit to the will of the people because there are certain things that you have to remove from democratic discourse. If you think that interracial marriage is one of those, if you think that the equality of people generally is one of those, and I think you also have to agree that the full humanity of women and girls is one of those.
Do you want to respond to that before we get to our closings?
Well, I want to make 2 points, I guess. One is I disagree. I think that science can tell us what the unborn human being is. From the moment of conception, basic embryology tells us that it is a human being, with its own unique, DNA, and it's distinct from its progenitors, and it's a human. Now, whether it's got a soul, that's a theological question. Whether it's a legal person, that's something we can debate. But I think science, in fact, can tell us what it is. The second point I just want to make about this point that a view that abortion should be illegal or is morally wrong somehow implies that women are not full human beings. Again, I already tried to make the point that I think autonomy is not a kind of unlimited thing, even for women. But I just want to push back because I think that abortion, telling a woman that she needs access to abortion in order to be equal to men, I think that is, that's taking the male body and the male experience as normative. Right? Everyone, or maybe not everyone, but I think in my experience, if we hear of a man who gets a woman pregnant and abandons her and his child or walks away, we think he's a cad. That's the word my mom would use, maybe you have a different word. We think less of him. We think he's, not doing the right thing, right? Why is it that we would think that a woman doing a kind of similar thing, right, is something noble or, expressing her full humanity? I think this idea that in order to be a person, a woman has to have the same ability to walk away from her child as a man denies really the full expression of being a woman.
Okay, I think we're at time, right? So why don't we get to your 2-minute closings. I will start with you, and then you can have the last word. Actually, I'll have the last word. I'll tell everyone what I think.
The side of the abortion issue for us. I think this is the first time I've ever been accused of being heteronormative, so this is cool. It is not by any means the argument to say that women need to be like men or that we're asking for something that men get. It's to say that women should not be treated as lesser than. Men will never be faced, biological men are never faced with the possibility of having to have their body taken over by another being, whatever you want to call it, right, is never going to require the sacrifice of someone's actual body if you are a biological male. So if that's the case, that means that men are free not to have that kind of burden. But we don't have to say it's an exact one-to-one, it's pregnancy or something else. It's really just the ability to say, no one can invade my body. Let's talk about it in terms of sexual assault, talk about it in terms of penetration of other kinds. You are allowed, all of us are allowed, and it's not heteronormative or trying to look like the masculine ideal, to say we should all be able to say you cannot do intimate things with my body without my permission. And that we single out women and girls. Only women and girls are told, except you. Because the thing that we think that you should do without your consent, that we can force you to do even if it kills you, literally kills you, is something that we, the state, feel so strongly about that we can force you to do it. That is something we don't tell men. We do not tell anybody but women and girls, you don't get to make that decision.
I'm sorry, I have to sorry, I can't help myself. But didn't you just answer that point by saying men don't have the same, because men can't get pregnant, of course we're only saying it to women because it only impacts women.
Well, the analogy that was being made here was to say a man who abandons his child as a cad, why do we celebrate a woman for doing the same thing? We don't, because first of all, no one celebrates abortion, and secondly, it is not the same thing. It is not about saying, I'm going to walk away. And by the way, men do that all the time. There's a lot of walkaways here, right? It's not as if that's an extraordinary circumstance. But we're not talking about whether or not you choose to take care of the child that you have brought into the world and have decided it has been determined that you have a parental relationship with. We're talking about whether or not you are allowed to say to any other person, even if you want to call them a person, you are not allowed to take up residence in my body or to take up any. The analogy could be sexual assault. The analogy could be using somebody's body for slave labor. I think the analogy is quite clear. You can't enslave another person. So we should all have that same right. Nobody should be allowed to tell us to put our bodies into intimate service for any reason, period.
All right, you get the last word?
All right, well, I think we're a little far afield from tonight's resolution, right?
Which is what
was Dobbs correctly decided.
Which is what I predicted might happen.
And to sum up, right, I think that Dobbs was correctly decided. For nearly all of this nation's history, abortion was considered the taking of a human life and therefore treated as a crime with no serious claim that it enjoyed constitutional protection. And I think Dobbs rightly overturned Roe's judicial overreach. I think, Dobbs is not, it's an act of constitutional restoration, but it's not the end of the story. I think, obviously, as tonight's discussion shows, never forget that law is normative, right? It tells us what we ought to do and ought not to do. And in order to make sense, to be intelligible or rational, human law has to presuppose prior claims about its object, that is the human person. And so these difficult questions, right, about what pregnancy is, what is the relationship between the mother and the child, what is the act of abortion, those are the questions we should be talking about, right? A recent essayist in Plow magazine put it this way: there are two questions on which the abortion debate hinges. First, when do we become a person? And second, when is it permissible to take a person's life? And I would argue that to make the choice to take the life of an unborn child a right is to threaten similar violence against any inconvenient or unwanted or dependent person at any stage of life, and deprives a community, including its women, of the liberty that is the foundation for the flourishing of us all. So tonight's discussion was just meant to be something preliminary to all of that, which is whether the Constitution protects the right to abortion. The answer to that question is no.
Okay, all right. Thank you both. Very spirited debate. And I'd like to thank the Federalist Society for inviting me for the third time. Maybe the next debate, maybe if it's about presidential tariffs, that would be nice.
We already did that, so that's.
We already did that.
Maybe after this.
Who'd you get to moderate that one?
That was Dean. Yeah.
Oh, yeah.
Well, yeah.
Yeah, you don't want to give the dean something controversial.
Yeah.
Just the federal judge.
Exactly.
All right,
Yeah,
well,
we can handle it.
yes, well, maybe people will be mad at me for some other reason. All right, thank you very much to both of you. Thank you, all of you. I'll be sticking around for a little bit until we have to go to dinner, in case anyone has any other questions. And other than that, you're free to go.
Thank you, everyone.
Thank you.
Have we met before?